everyone. Here I am with the amendments that is applicable for compliance management, audit and due diligence. You guys can be thinking, why is that I'm so late in uploading the amendments? Because there are no amendments, people. There is only one amendment which is relevant to us, that is in chapter number 6. It's just probably 1 minute amendment. Yeah, this always remember, whenever there is an amendment which is called as miscellaneous. Miscellaneous means it does not fit in any of our chapters. But now imagine if you are referring to Companies Act. In Companies Act, somewhere else there has been an amendment. Is it there in our syllabus? The answer is no. So some other place, some amendments have happened that would have also been given to us in our syllabus. But here I'll tell you the whether is it important or not. I would say 99% it is not important to you for your exams. I'll tell you why also. Because the context of this will not be there in your syllabus. Now, for example, they will say in a place, say 30 days. Earlier, we used to take 30 days from the date of allotment. Now, the amendment will be that allotment word will be removed. So, now it's an amendment. Yes, it's there in some other place in Companies Act. Should we know? Okay, we'll know. Now, 30 days you have learnt. Okay, the 30 days is in what context? That do you know? The answer is no. Because that context will not there, it will not be there for you in our syllabus. That's why I say miscellaneous is not that important for us, because you will not have the context for it. That's why it is not important. But yes, nonetheless, wherever it is something we can see, I will show it to you. Clear? The first one only we'll say, there is non-compliance penalties and adjudications, one of the biggest chapters that we have had. So where is the amendment? If you guys are using my book, if you guys go to 6 point, if I'm not wrong, 3.2 or something, it comes in 6 point adjudications. Yes. Okay, it comes somewhere here, rule 3. Yeah. 1 second, where did that go? But do we need to know the context? The answer is no, but I'll tell you what it is. Yeah. Yes, here this is where the amendment has happened. Adjudication process, we had something called rule 3. Here they have added something, and that is only called this particular thing. A new section called 3A has been added after rule 3. Now what is it? I'll give you one background. So earlier you used to remember, there used to be adjudication and all. Now what do you mean by adjudication? Imagine if there is any wrongdoer, we issue summon to him. We will ask him to come and represent himself before the authorities, before adjudicating authority. We can call for witness, we can give notices, we can ask for documents and evidences. All this we used to do in the case of adjudication. Basically, if there is a wrongdoer, we will tell him to come and represent himself before the authorities. Accordingly, we will decide the matter, whether to give penalty, to not give penalty, as the case may be. Now, what is the amendment here? Amendment is nothing but, people, MCA is going towards something called as e-adjudication. What do you mean by e-adjudication? E-adjudication means nothing but we are going away from physical mode. We are trying to introduce everything in the terms of electronic mode. Now, what do you mean by electronic mode? Nowadays, if at all the court hearings, anything should happen, wherever possible, we are trying to do it over internet, that is over online, to do away with the physical mode. Why? It saves a lot of time, infrastructure, and we can hear speedy disposal of cases, right, when compared to a physical matter. Now this will be more aligned, it will be more organized. So that is one amendment. That is the only amendment relevant to you. Sir, now you are saying everything is online. Everything is online. Witness, calling a person, document inspection, every evidence, everything is online. Sir, what about giving of notice? Giving of notice is online, meaning we will give it to you by email. Sir, what if we do not have your email ID? If the authorities do not have your email ID, then they will see if your address is there with them. If the address is there, then we will send you the notice by post. Sir, what if even the address is also not there with us? If the address is also not there, people, then on MCA platform, we have something called as e-adjudication. It's like one page, or you can say it is like one website in MCA only. In that e-adjudication, people, we will place this notice. That's all. So first is we'll try to give it by email. Second thing is we'll try to give you by notice if we have your address. If that is also not there, then we will just post it on our platform. That is e-adjudication platform. From there you have to pick it up. How you pick it up, it is your headache. That's all. That is your only relevant amendment in compliance management. See, adjudication platform. That's a new thing that they are coming up with. What is it called? It's called e-adjudication platform. Okay. On the commencement of this, after this particular thing, all proceedings, including issue of notice, filing reply, documents, evidence, hearing, attendance of witness, even passing of orders, payment of penalty, everything will be of adjudicating officer and regional director under these rules shall take place in electronic mode only through the e-adjudication platform, which is recently developed by central government. Sir, this is what I told you with regards to the notices. The first thing, we will try to send it to you over your email only. If email is not there, then we will give it to your address. That is not there, we'll put it in the e-adjudication platform itself. Last intimated address, this is for physical copy. Send the notice by post. Correct? The first one is email. Agreed. That's all, people. That's your relevant amendment now. That's all. I'm saying if you want to end it here, you can end it here also. Wherever there are other aspects are there, I'll try to tell you. If not, I'm telling you that is also not required because context is not there. Yes. See now, like this, MSME form 1 shall be substituted. What do you mean by that? Earlier we had some version, now it is a new version. Will that be there for us? The answer is no. First of all, this context itself is not there for you. So that's what I say. It's not relevant for you. You will not understand. Why? The reason is we don't have the context. We don't have that in our syllabus at all. How will we know? Any other relevant amendment? See, now there is something called as DIR3 KYC. Yeah, what is this? Every director, every year, they had to do something called as OTP verification. Meaning, if you, first thing, if your email ID and if your mobile number is not changed, every year, there will be a OTP that will be sent to your number. You need to verify and you need to say, I'm still alive. That was called as DIR3, meaning Directors Verification, KYC verification. Sir, what if my mobile number changes? They gave you one scope. What is that? By 30th of September, every year, if at all there is any change in your mobile number or your email address, you are free to update it within 30th of September. It's not even amendment. It was already there. Now they're telling you, you can update it. Sir, what if in the same year, my number changes 2 times? So earlier, they did not say that you have to file it by 30th September only. After that, if it changes also, you could have filed. Now you need to file it by 30th September only. Sir, if it is after that, or if I have to change my number twice in a year, then people, I need to pay 500 rupees fees. Earlier, this fees and all was not there. Now they are telling you that you need to pay 500 rupees fees. Now you think, do you know this DI3 KYC, context, nothing, no. That is what I am telling you. Your amendments will be there, but this does not make sense. Agreed? You can absolutely leave, it's okay. Next one. Incorporation amendment rules. Now, what are those, people? Earlier, now whenever you have, imagine if you incorporate a private limited, the word private limited should be in the name of the company. Public limited, limited should be in the name of the company. OPC, private limited should be in the name of the company. If it's a Nidhi company, then you should have had the word Nidhi limited. Now, people, that is no longer required. That is omitted. So today you can have a Nidhi company without having the words Nidhi Limited in it. You can it is removed. You need not mandatorily have the word Nidhi in the name of the company. That's the amendment. Simple, done. Same thing. Correct? Next one, see IEPF. We do not have IEPF in our thing at all. We had it in Companies Act. So here the forms are substituted. IEPF 3 substituted with IEPF 4. IEPF 7 is substituted with IEPF 1. Earlier we used to use IEPF 3. Now they are telling instead of IEPF 3 you use IEPF 4. We used to use IEPF 7. Now they are telling IEPF 1. I hope just to give you context. What is the context for all of this? The context is nothing but earlier whenever if a company declares dividend, if that dividend is not claimed for a period of 7 years, then what we used to do, we used to transfer that dividend. Along with the dividend, we used to transfer shares also to an account called as IEPF account. Now whenever you're transferring this money and shares, you need to file certain forms with the government that I've transferred money, I've transferred shares. Now they are trying to reduce your burden. Instead of telling there are 2, 3, 4, 5 forms, they have substituted with as less forms as possible. That is the amendment. Now, is it required? Answer is no. Because for you, IEPF 3 was also not there, IEPF 4 was also not there. So, does it make sense? The answer is no. But yes, that is the amendment. Remember and go. See, same thing. Merger of forms. IEPF 3 is merged with IEPF 4. IEPF 7 is merged with IEPF 1. Isn't it the same? That is ease of doing business. They have reduced your burden. That's all. Done. LLP. Now, what is that? Now, whenever a company wants to shut down, a company could go for something called as voluntary strike off. I don't know if you guys have, if you guys remember it. You guys had it in your company law. Something called as strike off. The entire strike off procedure for a company, which was earlier handled by registrar of companies, they transferred everything to another authority called as registrar of not companies. Now it is called as registrar of CPACE. A new body was created. The new body was called as CPACE. So all the strike off matters of a company was handled by registrar CPACE going forward. Today what they have done, not only for company, even for LLP also, wherever it is voluntary winding up, they are telling that registrar of company is very busy. Now you cannot burden him with other matters also. Let us create a new department. They created a new department called as CPACE. Now that CPACE will take care of closure of companies also. Amendment is LLP. Company it has been there 2 years, it has already been. Now they have also brought in that amendment to the LLPs also. That's the amendment. See. Center for Processing Accelerated Corporate Exit. That is the meaning of CPACE. Center for Processing Accelerated Corporate Exit. See, corporate exit means what? You want to shut down. Accelerated means what? Fast. So they are helping you to make it more speed, faster. That's the meaning. Here I'm done. What are the next ones are? Same things are. Earlier, sir, whenever a company gets incorporated, registration of company. Now, ROC is again overburdened. So, what did they do? They formed a new body. That new body is called as CRC, Central Registration Center. It was called as CRC. So, all your name approval, incorporation of company, some matters used to be directed to CRC and not ROC anymore. Again, to reduce the burden of ROC. So now what did they do? This is not amendment, it was already there from the last 4 or 5 years. That's the same procedure. Whenever a company is getting name approval and all that request, it will directly go to CRC, Central Registration Center. Meaning irrespective of ROC Karnataka, ROC Tamil Nadu, everything will go to the center. Only one department used to take care of all these incorporations now. Now what is the amendment is? Nothing but If a foreign company is coming to India, what is a foreign company? A company which is incorporated outside India, and if they are having a place of business in India, we used to call them as foreign companies. Whenever a foreign company comes into India, within 30 days, they have to file a form called as FC1 with ROC. That, sir, we are a foreign company, we have come and we have established our business in India. They had to intimate a lot of details. Now going forward, they need not tell it to ROC, they can tell it to CRC. That's the amendment, done. For a normal company, it was already there. For a foreign company, they recently introduced. Important, absolutely no. Indian accounting standards and all, absolutely forget. Not at all important. Next one, again same thing, IEPF, Investor Education Protection Fund. One more thing now, what they have, again that's what I'm saying, it's not required for us. In IEPF, what used to happen, what is IEPF people? Whenever I take, I declare a dividend, if that is not claimed for a period of 7 years, then what I used to do, I used to transfer it to a different account, correct? That is IEPF account. Now what if there is a problem here, people? Meaning, let us imagine if by mistake I transfer some funds of a person without me properly checking it. Technically, if you see, it is a non-compliance. Now let us imagine, someone comes and claims that this is my money. After some 15 years, the company does some verification, the company says, yes, it is his funds, we'll give it away also. But after some another 5 years, someone else will come and say that is, I am a rightful owner of those shares. How did you give it to the other person? To avoid all of this, what did the center say? What does the government say? We have to introduce something called as insurance coverage. What is insurance coverage? Whatever are the shares that we transfer to the IEPF, on that now you need to take mandatory insurance. So tomorrow if we give the shares to any owner even by mistake, so the true owner is always protected. That's the intention. Understood? Pakkana. So now you need to take something called as insurance. That's all. That's an amendment. Not very big amendments and all that. You can absolutely leave. Accounting standards and all leave. Not relevant for us. Next one, sir. People, we know that annual general meeting or EGMs, we need to always conduct it by AGM or EGM. We need to always conduct it by physical meeting. Yes, that's what is, given in Companies Act. But after 2020, that is after COVID, every year, I repeat, every year, MCA will give you a notification saying that even this year also you can conduct your AGM not by physical, you can conduct it by audio visual means, meaning you can conduct it electronically. They gave it in 2021, they gave it in 2022, 2023, now they have given it for the year 24-25 also. So whatever is the AGM that you are going to conduct in 2025, you can conduct that AGM also in electronic mode. So every year they are giving it as a clarification. Remember, it is not directly added in the section that you can conduct your AGM by electronic mode. That is not directly added. So every year there is a relaxation given as a notification by MCA. Currently that is the method followed. Clear? That is an amendment. So for this year also you can conduct it by electronic mode is what they are saying. The next one, sir, they have introduced something called as Rule 9B. What is Rule 9B? Just for your information, I'll tell you. We had something called as Rule 9 of Prospectus and Allotment of Securities, Rules 2014, Companies Act. According to this, whenever a company, if it is going for an IPO, it has to mandatorily in demat form. So this is for all the public companies becoming listed companies. Next, they introduced Rule 9A of Prospectus and Allotment of Securities, Rules 2014. If there is any public company, if you are issuing any shares going forward, not IPO, if you are even doing private placement, if you are a public company, any new issue, it has to be mandatorily in demat form going forward. They introduced an amendment called 9A. Now they introduced one more amendment called 9B. all the private companies going forward, any new issue, you have to mandatorily do it in demat form. Only exception to this rule 9b, there is one exception. The exception is if you are a small company, you can continue to hold your shares in physical mode. Apart from the small company, rest all the companies have to mandatorily convert their shares into demat form. New amendment rule 9b, it's actually a very good one for company secretaries, because in physical mode a lot of frauds can happen. The moment it is electronic mode, accountability comes into picture, you cannot do frauds. So when accountability comes into picture, your regulatory requirements will become more, meaning you have more scope of making money. That's the beauty. That's what is 9b's importance. Today private companies are also coming under stricter rules and regulations. Of course we cannot do it for everyone. You can see phase wise they did it. So next eventually some 2-3 years later they will do it for small company also, but currently only for private companies. Demat form is mandatory going forward. Clear? Next one again, accounts, you can ignore it, it's absolutely fine. Okay, the last amendment, sir. What is this nothing but people? Earlier we used to have something called as auditing standards. We used to have something called as auditing standards for companies. Yeah, whenever companies accounting and auditing and all happens, for that they have something called as auditing standards. So today they have passed one amendment, and that is nothing but section 34A of LLP has been added. What is section 34A? Nothing but whatever are the auditing standards that applies to a company, those auditing standards will cut, copy, paste, will be applicable to the LLP as well. That is the amendment. Done. So that's your compliance management audit DD amendments, people. There is nothing much. The first amendment itself is our only amendment, or else rest all is okay, chiller, you can absolutely ignore. But yes, just know and go. So I hope your preparations are going good, and I wish you all the very best. Do well in your exams, and do let me know if your results go either ways. I'll always be there here to support you. Yes. Thank you so much. See you all. Bye bye.